For years, people talked about the Epstein files like they were one locked folder, one final vault, one single release that would explain everything. But when the newest waves of documents finally came out, what they revealed was something very different. Not one perfect answer, not one master list, not one dramatic final secret. Instead, the new release exposed something much more unsettling: the sheer scale of the government's holdings, the massive number of victims, the depth of the documentary trail, the presence of thousands of videos and images, the inclusion of emails touching elite circles, and at the same time, the government's explicit statement that some of the biggest public theories were not supported by what investigators found. By January 30, 2026, the U.S. Justice Department said it had published nearly 3.5 million pages of responsive Epstein-related material, including more than 2,000 videos and 180,000 images, under the Epstein Files Transparency Act. Officials said the production drew from multiple criminal cases, FBI investigations, and the Inspector General's review into Epstein's death. And yet, even with that mountain of material, the release did not bring the kind of closure many people expected. Instead, it created a new phase of the scandal, a phase where the most important question is no longer just, what was hidden? It is also, what do these files actually prove? Tonight, we're breaking down 10 new shocking revelations from the Epstein Files release. What's truly new, what changed, what was confirmed, what was debunked, and why this case remains one of the most disturbing intersections of trafficking, power, secrecy, and public obsession in modern American crime history. This is 10 new shocking revelations from the Epstein Files release. Part 1. Revelation. Number 1. The scale of the release was far bigger than most people expected. The first revelation is the simplest, but maybe also the most stunning. The files were not small, they were not symbolic, and they were not just a few binders of old paperwork. On January 30, 2026, the Justice Department announced that it had published over 3 million additional pages, bringing the total public production to nearly 3.5 million pages in compliance with the new transparency law. That is not a normal disclosure. That is a massive archival dump covering years of investigations, prosecutions, and reviews. That scale matters because it tells you instantly that the Epstein files are not one thing. They are a legal universe, a sprawling mass of evidence, correspondence, reports, filings, investigative material, and records that accumulated across multiple jurisdictions and multiple phases of the case. And when people hear 3.5 million pages, they often assume that means there must be one final explosive answer hidden somewhere inside. But sheer volume does not automatically mean clarity. Sometimes it means the opposite. Sometimes it means the truth is spread across thousands of fragments, buried under years of litigation, agency handling, victim privacy protections, duplicate records, and public confusion. That is the first shock of this release. Not that the archive exists, but that it is so enormous that even now, after years of scandal, the public may still underestimate just how large the documentary footprint of the Epstein case really is. Part 2. Revelation number 2. The release included thousands of videos and hundreds of thousands of images. The second revelation is the media footprint of the archive. The Justice Department said the January 2026 publication included more than 2,000 videos and 180,000 images. That is an extraordinary number by any standard, and it immediately changes how people should think about the case. This is not just a paper scandal. It is not just witness statements and courtroom filings. It is also a visual record, a digital record, a case preserved through photographs, recordings, images, and video evidence gathered across multiple investigations and legal proceedings. Now, that does not mean all of those images or videos are publicly viewable in unredacted form. The DOJ said some materials were withheld or redacted to protect victims, and the July 2025 DOJ FBI memo said the government's holdings include huge amounts of sexually explicit material and child sexual abuse material that would not be publicly released. And that matters, because one of the central tensions in the whole release is this. The public wants transparency, but full transparency is impossible when the evidence itself contains victim-identifying and exploitative material. So the second revelation is not only about scale, it is about the kind of case this really was. A case with such a vast evidentiary image trail that the government itself had to say openly, a large amount of what exists cannot and should not be made public in raw form. That makes the files feel darker, not lighter. Because it reminds you that behind every headline, every theory, and every famous name, the real center of this story is victimization, on a scale that even now is hard to fully absorb. Part 3. Revelation number 3. The released material came from multiple cases, not just one Epstein file. The third revelation is one that cuts through years of public misunderstanding. There is no single master Epstein file. The DOJ said the 2026 production came from multiple primary sources, including the Florida and New York cases against Epstein, the New York case against Ghislaine Maxwell, the New York matters investigating Epstein's death, the Florida case involving a former Epstein butler, multiple FBI investigations, and the Office of Inspector General investigation into Epstein's death. That is huge. Because it means the phrase Epstein files is really shorthand for a huge bundle of overlapping legal histories. The original Florida prosecution, the later New York federal case, the Maxwell prosecution, the jail death investigations, civil litigation-related materials, and broader FBI holdings tied to Epstein over time. This matters because it explains why so many public arguments about the files end up going nowhere. People think they are talking about one archive, but often they are talking about completely different categories of records. One person is referring to court exhibits, another is referring to jail records, another to contact books, another to flight logs, another to FBI submissions, another to civil doc unsealings. The third revelation is that the files are not a tidy disclosure. They are a layered case ecosystem, and once you understand that, the whole scandal starts to look different. Less like one locked box, more like a fractured map of one of the most sprawling sex trafficking scandals in modern history. Part 4. Revelation number 4. The government said some of the released material may be false, fabricated, or sensationalist. This is one of the most important revelations in the entire release, and one of the least discussed. The DOJ said the production may include fake or falsely submitted images, documents, or videos because everything sent to the FBI by the public that was responsive to the law was included in the release. The department also said some documents contain untrue and sensationalist claims. That is a bombshell, but not in the way people think. It means the released archive is not a perfectly clean truth machine. It is a file dump, and file dumps contain noise, rumors sent to the FBI, political submissions, false tips, garbage mixed in with genuine evidence. That means responsible viewers, journalists, and documentary makers have to be extremely careful. Because once a document appears in an official release, many people assume that gives it official credibility. But the DOJ itself is warning the public not to make that mistake. That changes the whole landscape. Because now, the question is not only what got released, it is also what kind of material got swept into the release process simply because it had been submitted, stored, or collected. And that matters in a case where misinformation spreads fast. It means not every explosive page is equally trustworthy. Not every screenshot is meaningful. Not every allegation in a government-held record is a verified fact. The fourth revelation is that the archive is part evidence, part legal history, and part contamination zone. And if you do not know the difference, you can easily misread the whole thing. Part 5. Revelation number 5. The DOJ said it found no incriminating client list. This is the revelation that probably shocked the public the most. For years, countless people online treated the idea of an Epstein client list as if it were the final missing artifact, the document that would name everyone, the one list that would settle the scandal. But in its July 2025 memo, the DOJ and FBI said their systematic review revealed no incriminating client list. That is a very specific statement, and it does not mean nobody associated with Epstein ever did anything wrong. It means investigators say they did not find the kind of definitive master list that so much of the public had imagined. That is an enormous distinction, because one reason this case has lasted so long in the public imagination is the belief that one final document was being hidden. But the government's own review says that based on what it examined, there was no such incriminating list sitting in the holdings. For some people, that was disappointing. For others, suspicious. But whether people like it or not, it is one of the most important official findings in the new release era. And it forces a harder, more adult understanding of the case. Real criminal conspiracies are not always neatly documented in the way internet culture imagines. Sometimes there is no cinematic final ledger. Sometimes there are only fragments, records, contacts, meetings, allegations, and crimes, without one clean index tying everything together. That is what makes this revelation so powerful. It closes one of the biggest myths, even if it leaves many people unsatisfied. Part 6, Revelation number 6. The review also said it found no credible evidence of a blackmail operation targeting prominent people. The sixth revelation is closely tied to the fifth, but it deserves its own section. The DOJ-FBI memo said the review found no credible evidence that Epstein blackmailed prominent individuals as part of his actions. Again, this matters because it challenges one of the biggest long-running theories around the case. For years, people assumed Epstein must have been running a large compromat-style operation, that the houses, cameras, and guests all pointed towards systematic blackmail of elites. But the government's official review says it did not find credible evidence supporting that claim. That does not erase the abuse. It does not erase trafficking, it does not erase grooming, and it does not erase the possibility that Epstein sought leverage in various ways, socially or psychologically. But it does mean the specific theory of a confirmed, evidence-backed blackmail program was not supported by what DOJ and FBI said they found. This is one of the hardest parts of the modern file release era. Many of the most viral theories are not the same as the strongest supported findings. And in the Epstein story, the truth is already horrible enough without needing unsupported additions. The confirmed scandal is massive. The proven exploitation is devastating. The institutional failures are undeniable. So the sixth revelation is less about removing drama and more about replacing rumor with the official evidentiary baseline. Part 7. Revelation number 7. The government said it found no basis to open cases against uncharged third parties from the reviewed material. The seventh revelation may be the most legally significant. The July 2025 memo says the review did not uncover evidence that could predicate an investigation against uncharged third parties. That is an extraordinary sentence, because it speaks directly to the question millions of people keep asking. Did the files point investigators toward a wider ring of criminally chargeable people who had not yet been pursued? According to the memo, based on the holdings DOJ and FBI reviewed, the answer was no. Now, that does not mean every moral or social question is resolved. It does not mean everyone who associated with Epstein was wise, ethical, or beyond criticism. It means something narrower and more important. The government said the materials it reviewed did not support opening new investigations into uncharged third parties. That is a legal statement, not a social one. And it is one that cuts directly against the expectation that the new release would trigger a wave of new prosecutions. This is one reason the 2025-2026 release period became so politically explosive, because the files were expected by many people to expand the scandal outward. Instead, one of the biggest official takeaways was that the reviewed evidence did not justify that move. That is not the ending many expected, but it is undeniably one of the biggest revelations. Part 8. Revelation number 8. The DOJ said the record confirms Epstein harmed over 1,000 victims. This may be the most important revelation of all. In the July 2025 memo, the DOJ and FBI said their review confirmed that Epstein harmed over 1,000 victims. Over 1,000. That number should stop everyone in their tracks, because it shifts the case out of the realm of elite scandal and back into what it fundamentally was: a large-scale exploitation system, a predatory structure, a years-long crime pattern involving an enormous number of harmed people. When people get lost in the names, the politics, the flight logs, and the release drama, they can forget the human scale of what the files are really documenting. This number brings that scale back. It tells us that the core of the case is not celebrity adjacency. It is mass victimization, and it also explains why the government continues to heavily redact and withhold so much. The memo says sensitive victim information is woven throughout the materials, including names, likenesses, descriptions, birthplaces, associates, and work history. That means transparency in this case has a built-in limit. Not because the public does not deserve answers, but because the victims deserve protection too. And that tension between public exposure and survivor privacy may be the single hardest balancing act in the entire release process. Part 9. Revelation number 9. The new release included fresh email evidence showing how wide Epstein's social network remained. The 9th revelation is one of the most headline-grabbing. Reuters reported that the January 2026 release included emails showing that Commerce Secretary Howard Lutnick apparently planned a 2012 lunch visit to Epstein's island, years after claiming he had cut off ties. Reuters also reported that in another exchange, Elon Musk asked whether Epstein was planning any parties, but declined an invitation to visit the island. Now this is where extreme care matters. These emails are newsworthy because they show the breadth of Epstein's elite social network and because they surfaced in an official release. But being mentioned in those records is not proof of criminal wrongdoing. Reuters itself noted that the files include many prominent names and that previous releases had revived scrutiny around social links, while some individuals have denied wrongdoing or said they regret their association. So why is this still a major revelation? Because it reinforces something the public has long suspected. Epstein's access did not vanish as early, as cleanly, or as completely as many people later suggested. Even after his 2008 conviction, the record still shows social reach into highly prominent circles. That does not make every contact criminal, but it does make the social story uglier, because one of the darkest truths in the whole case is that association with Epstein often lingered long after there was already enough public reason for people to stay far away from him. And that is what makes these fresh communications so damaging reputationally, even where they do not establish criminal conduct. They remind us that Epstein's power was not just financial. It was social, and social power can outlive scandal far longer than people want to admit. Part 10, Revelation Number 10. The files did not end the story. They reopened the debate about justice, secrecy, and what the public is still missing. The 10th revelation is less about one page and more about the effect of the release itself. The files did not close the case in the public mind. They reopened it. The transparency law was signed in November 2025 after mounting public and political pressure for fuller disclosure. Reuters reported that the law required DOJ to release documents within 30 days, potentially with some information withheld. Then came the huge January 2026 production, and instead of ending the story, it started a new one. A fight over redactions. A fight over whether all pages had really been produced. A fight over what counts as meaningful transparency. A fight over whether the public had been oversold the promise of the files in the first place. That is the final revelation. Even after millions of pages, the Epstein case still sits in a strange space between exposure and incompleteness. We know much more than we once did. We have official findings on some of the biggest public theories. We have massive releases. We have Maxwell's conviction and sentence. We have the Florida scandal, the 2019 federal case, the official suicide finding, and the Inspector General's account of jail failures. And yet the public still feels unresolved. Partly because Epstein died before trial, partly because the early 2008 deal still feels like an injury to justice, and partly because once a scandal reaches this scale, no release can fully satisfy the need for moral closure. That may be the deepest shock of all. The files are enormous, but they still cannot undo what happened. So what are the 10 new shocking revelations from the Epstein files release? That the archive is vastly larger than most people imagined, that it includes thousands of videos and hundreds of thousands of images, that it comes from many different legal and investigative streams, that some included materials may be false or sensationalized, that DOJ says it found no incriminating client list, no credible blackmail evidence, no basis to investigate uncharged third parties from the reviewed holdings, that the record confirms over 1,000 victims, that new communications still expose the breadth of Epstein's elite network, and that even after millions of pages, the case remains morally unfinished, because the real story of the Epstein files is not one final hidden secret. It is something much worse. It is the story of how much evidence can exist around a predator, how many people can be hurt, how many institutions can fail, and how even the largest release in the world may still leave a public feeling that justice came too late.